Hi, I'm Anna Denton-Jones, and in today's session I'm going to be talking about some new EU regulation dealing with artificial intelligence. Now, you might be thinking we exited the EU, we don't need to worry about what the legislation is going to say there. If you work as part of a group of companies, for example, across Europe, and you have colleagues in Europe, then you are going to have to worry about, for example, you wouldn't be able to buy products that roll them out across the whole group if they were going to be in breach of this legislation. Equally, if you were to buy products that are going to be operated in Europe, for example, it might be an Irish product, then because decisions within that software are going to be made in Europe, then it would be captured by this legislation. And in any event, it's interesting for us to know what's happening there because it may well influence regulation here in due course. Our current government have said they're not going to do anything, but it's highly likely, for example, if a new Labour government came in, then the same sort of model will be followed. So what the legislation does is create tiers, if you like, of the kind of AI that we're talking about and the level of regulation that AI would have. So at the top level, you've got some AI that's actually going to be banned outright. Now, for our purposes, in employment law and HR, that probably means, or that does mean, the kind of AI that reads the emotions of your staff. So that will be banned outright. So if you're currently using any products that work on that basis, then you wouldn't be able to going forward. The next tier down is the sort of most high risk type of AI. And for our purposes, sort of two areas that get hit there. So that's anything in the recruitment field. So helping you sift candidates, correspond with candidates, anything to do with recruitment, that's going to be captured. And anything that relates to decisions that are going to be made during the employment life cycle. So whether that's to terminate somebody's employment, whether it's how tasks are allocated to the person, whether it has an impact on promotion or who gets training and things like that. Anything, any AI that relates to the employment life cycle will have extensive regulation. Then there's kind of general purpose AI, which has a lower level of regulation, and then the sort of lowest level AI, things like a chat bot, you'll start to notice that where you're not clear whether you're interacting with a human or not, the law in Europe at least will be driving notification to the user so you know when you're speaking to a chatbot, when you're speaking to a human. So transparency, basically. Similar to GDPR in terms of fining being based on global turnover. That model's being used here as well. The maximum fine would be €30,000 under this legislation, or 7% of global turnover. The majority of the regulation will be aimed at the providers of AI, but where we're using it, we might have obligations around monitoring our use of it, record keeping, ongoing transparency about how decisions are made, and you know how people get information to access decisions that are being made about them as well. So there is possibility that if an employer modifies a product that they've purchased substantially, that they can be deemed to be the provider and therefore subject to much higher levels of regulations. We have to watch out for that as well. So worth understanding, just in outline, what's probably going to be happening and may well happen here at some point in the future. If you've got any questions, it's adenton@refreshinglawltd.co.uk. Thank you very much.